Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hey everyone, welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Retzel and Andrus. Today I'm joined by my partner, Donna Hartl, who's part of our tax group, and she's going to be talking specifically about planning for your demise, planning for your future, and really thinking about the implication of how some basic estate planning can protect you and your family. And this is of particular concern for healthcare practitioners, and we're going to discuss why. So thanks for joining me, Donna.
Oh, you're quite welcome. It's a great topic because it affects everybody, no matter what profession you're in, but it especially affects people in the healthcare area because so many people are busy that they don't quite get time to focus on this part of it. There's always tomorrow and then the day after, and sometimes it's better just to get it done. What's good about an estate plan is it's a foundation. You can always change it. You can always add on to it. You can always modify it as things happen in your life. But to have nothing is probably the worst scenario you can have. Having a will, trust, and powers of attorney provides actually a lot of advantages, including avoiding probate, protecting your assets, and ensuring that your wishes are carried out in the event of not only death, but if you become incapacitated.
Right. So let me just add one thing. The reason I think this is so important for doctors is a lot of them have assets. A lot of them are well compensated. They have money sitting in a savings account. They may have other types of assets. And if they don't plan, as you mentioned, then it may not go to the people that they want. And just to be very clear, when does one end up in probate? Because I think we're assuming that people understand that they avoid probate by estate planning, but what is probate and how is it avoided?
Good question. In Illinois, and every state has a different dollar threshold, but in general, there's a dollar threshold from when you have to probate. In Illinois, it recently changed to be $150,000, which means if you have $150,000 in assets that are in your name when you pass away, everything locks up. And if you're not around to access that account, then somebody else has to. And so if you don't have a joint account holder, or if it's not named in a trust, it's just your name, Donna Hartl, on that account, nobody now can access that money until there's a legal ability to access it. And that's what probate does. And Illinois says if you have 150,000 or more, which you can easily have either in real estate in your name or in investments in your name, at 150,000, you must have probate in order to access those assets.
Okay, so simply by planning ahead, you can make sure that your family and loved one can get access to those accounts should something happen to you. Okay.
Correct. And here's the thing. You hear a lot about trusts. You can do something as simple as just having a will. And the will says, when I die, here's where everything goes. Great thing to have. But most people benefit from having a will and a trust combination. And the trust then reads like a will would read. But you can transfer assets to it during your lifetime and buy and sell things as you would as if it was in your name because you control your own trust. The beauty is because it's in the name of your trust, the Donna Hartl Trust, then nothing has to go through probate. And here's the time lag. If you're in Cook County and you die January 1st and you have assets in your name, it will easily be 2 to 3 months before we can get in front of a judge to get access to those accounts because they were in your name, you're over 150,000. If you have all your assets or those particular assets in a trust technically doesn't die when you die, and whoever you put in charge can access those assets the next day. So that's the big difference between the two.
Right. And one thing I want to mention is just doing it once and leaving it is not the thing to do. I mean, you're going to buy and sell things over time, so you need to make sure you're actually transferring them as needed into the trust. But also, your relationships with people might change over time. And I know we've had some situations where people didn't update beneficiaries or trustees or whatever the terminology might be, and they have an ex or somebody unintended as the overseer. Correct?
Yeah, in fact, I can tell you, currently we're dealing with a probate right now where the decedent died and he did his will before he remarried. And his will doesn't have anything about the new spouse because she wasn't a spouse then. So it's dealing with those kind of issues which are legal and awkward at the same time.
Right.
So I usually tell people pick up, even if you say nothing has changed, always pick up your documents between every 3 and 5 years and
Okay.
reread them, start from beginning to end, because you'll find something that you were like, oh, yeah, I forgot about that. So it's really helpful. And, I've had people come in to talk about making a change to their documents for one reason. And then they say, oh, yeah, I forgot to tell you we had a kid. So if you do it every 3 to 5 years, you will always catch things that you may not have thought of.
Okay. And one thing I also want to talk about when it comes to physicians, dentists, and other healthcare providers is that many of them either own an interest in a practice or other healthcare business, or they own their own practice. And one of the situations I quite often have to deal with is a solo physician, or maybe they're the sole owner of a practice, but not necessarily the sole one in the practice, and something happens to them. And then it falls on the family to kind of scramble to figure out, can we now try and sell this practice? Who can make decisions? How is it controlled? Who gets the proceeds of the practice? Is that the kind of thing that we can also talk about in estate planning documents?
Absolutely. In fact, you and I, Erica, probably had one of those situations about 3, 4 years ago. And your estate plan documents can be very specific. It can say, I own business A. I would like the business sold and I would like the proceeds to be distributed to my sister and brother. And it can be even more specific, saying, in helping decide what to do with the practice while it's being sold and before it's being sold, and help decide who to sell to and what terms, you can actually designate a person, whether it's your office manager at the office, whether it's a trusted family member. So it doesn't even have to be the same person that's handling all your other things. It can be, you can actually say, I want this person to help guide my attorneys on what to do with my practice. And that has been very helpful to do.
Right. When it comes to a licensed practice, the time frame for getting a practice sold is quite quick, because obviously the person who holds the license in states where you can't own it without a license, they've already passed away. So the time frame is very quick. Usually we say 6 months to a year at most, but there's no bright line on that. I do actually recommend to clients that if they have their own practice, or they own the practice but have a doctor working for them, that they have discussions about this with a colleague who might also have a license. So we know somebody who could step in, oversee the staff, and keep the practice going long enough to sell it. Because one of the
That's a
issues,
great idea and very smart to do, because if something happens to you on Monday, what's going to happen on Tuesday?
right, the patients can't be seen, and there's only so long where you can't see patients before practice loses all its value, and there is nothing to be sold for the family. So, estate planning documents are really important, but also having conversations with, colleagues about, covering for each other, helping out, and maybe documenting those discussions is a great idea as well. It's very sad
And you could
situation.
have that, frankly, if for a disability purpose. What if you get hit and or get in an accident where you're out of commission for 3 months? You should have a backup plan even for that. And the backup plan is probably similar to what happens if I pass away.
Absolutely. I mean, you might have disability proceeds coming in, but that's just money. At the end of the day, when you're ready to go back to work, is there a practice to return to, is the
Right.
question. So these are all great planning ideas. And, other industries, of course, this might apply as well. But when we're talking about healthcare, we're really limited. We've got licensed people. We've got, only certain people that can own or operate or provide services. So the situation is very unique. So in addition to planning what's going to happen with your assets and when you die, et cetera, we also want to think about, if something happens to you, who can keep the business alive?
Right.
And kind of as a related question, I guess, is I'm wondering about asset protection as well. And I don't know if you could speak to that, but doctors obviously, want to save their money and their business for their families should something happen to them. Does using a trust at all provide any asset protection as well, or is that something completely different? I know a lot of doctors are like, oh, all my stuff's in an asset, I'm safe. But can you speak to whether that really helps at all?
Sure. Asset protection has two main points to it. Just putting your assets in a trust don't necessarily protect you from creditors. Because if you can pull money in and out of the trust, and if you can change the terms of the trust, then for creditor protection, it's not going to offer you much value because they're going to say, well, you can take the money out, so give it to me. So there are different types of trusts you can use. There are irrevocable trusts where you put money in, but then you can no longer make changes to the trust. There's some ways to do some of that, but in general, the two main focuses of asset protection is it out of your control, and is it layered? Out of control means, are you prevented, even if you wanted to go screaming and yelling, I want my money back, that the trustee cannot automatically give you the money? So there's a stop block. So it's harder for the creditor to get at because it can't force a distribution back to you to pay your creditor. The other thing is layering. Layering means limited liability companies, irrevocable trusts, limited partnerships, where one owns a piece of the other. So instead of just putting something into an irrevocable trust, maybe put your business in a limited liability company and have that liability company owned by a irrevocable trust. Because even if a creditor might be able to get at something, if they have to keep going after layer after layer after layer, they will either get discouraged or they will have a reason to settle.
Right.
So
And one thing to mention is that some of this planning may or may not be available to licensed individuals. So, for
correct.
example, in certain states, a practice can only be owned by a licensed person, not by a trust, right?
True, but we've also got the investments that are kicking out of and into
Right,
the individual name that you
right.
can protect that way.
Yeah, so you really need to talk to someone who's familiar with the differences between who can own a licensed practice and how we can set things up to account for the fact that you may not be able to do things that other types of businesses can do. That's one of the things that Donna and I do with our healthcare providers that, a normal estate planning lawyer might not do. The other thing is that a lot of our doctors, dentists, and otherwise are using management service organizations, which are MSOs, where a lot of the profit of a practice is being drawn up to a business entity instead of a licensed practice. And there's a lot more estate planning and organization and protection that can be done at that level. So it's a nice planning feature as well when it comes to licensed practices.
Yes, MSOs are a great vehicle.
Right.
And
Absolutely.
again, it adds another layer. So it's separation. You keep in the business what needs to be because you have to be licensed, but then the other non-licensed parts of your practice can go elsewhere, and you can still benefit from the rewards of it.
Perfect. All right. So we talked about planning for the future, making sure you update your plan, taking into consideration if you become disabled or you die, and asset protection. And these are really key issues for healthcare providers. Are there any final thoughts that you want to share? I mean, this is a big topic. We could talk a long time about it, but really want to kind of plant the idea in people's heads that, we're coming to the end of a year. Don't let us get to 2026 without sitting down and thinking about your family and your business. right?
One last thought. Powers of attorney. A lot of people sometimes believe because I've got a will and a trust set up, I don't need powers of attorney because everything's handled. It actually isn't. You should have powers of attorney, and powers of attorney are either for your stuff, powers of attorney for property, or they're for your body, healthcare power of attorney. And the reason you need them is that they are applicable only during your lifetime. So when you pass away, your will kicks in. But you might be disabled. You might be unable to handle your financial affairs. And while you say, hey, listen, I put everything in trust, I can guarantee in 40 years, I've only had one client that I found had every single thing in trust. There's always something out there. There's a vehicle. There's a tax refund. There's some bank account everybody forgot about. So if you have a power of attorney, that person during your lifetime can access that and do what needs to be done. So a power of attorney for property. If you use, I'll give Illinois for an example. If you use Illinois' statutory form, then the third parties that rely on that form when you hand it to them have some protection that they're able to rely on that form and they don't have to question, is this person really the agent? So if they rely on it in good faith, they're protected. So the reason I bring that up is third parties are more inclined to want to see that form. The form is not required itself, but that's the one to use because that's what the third parties want to see. Same with the doctors and dentists and hospitals. They want to see the medical power of attorney on the Illinois statutory form because it offers them protections when they deal with the agent. So no matter what, I would always have a power of attorney for property, a power of attorney for healthcare. And frankly, you may want to have a separate power of attorney for your business that gives a person separate from who you give all your other personal property powers to. If you've got somebody different you want to handle issues with respect to your business. So consider that as well.
Perfect. Great advice. All right. So if you have questions about anything we talked about here, please feel free to reach out to Donna Hartl directly, email, call, or reach out to me and I'll get you to Donna or the right person with your question. You can catch our other podcasts at ralaw.com. And again, we thank you for joining me and Donna here at the Health Law Hotspot. We'll see you next time.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.